Muehler v. Mena, Supreme Court, 2005. Chief Justice Rehnquist delivered the opinion of the court. Respondent Iris Mena was detained in handcuffs during a search of the premises that she and several others occupied. Petitioners were lead members of a police detachment executing a search warrant of the premises. She sued the officers under 42 U.S.C. Section 1983, and the district court found in her favor. The Court of Appeals affirmed the judgment, holding that the use of handcuffs to detain Mena during the search violated the Fourth Amendment, and that the officers' questioning of Mena about her immigration status during the detention constituted an independent Fourth Amendment violation. We hold that Mena's detention in handcuffs for the length of the search was consistent with our opinion in Michigan v. Summers, and that the officers' questioning during that detention did not violate her Fourth Amendment rights. Based on information gleaned from the investigation of a gang-related drive-by shooting, petitioners Mueller and Brill had reason to believe at least one member of a gang, the West Side Locos, lived at 1363 Patricia Avenue. They also suspected that the individual was armed and dangerous since he had recently been involved in the drive-by shooting. As a result, Mueller obtained a search warrant for 1363 Patricia Avenue that authorized a broad search of the house and premises for, among other things, deadly weapons and evidence of gang membership. In light of the high degree of risk involved in searching a house suspected of housing at least one and perhaps multiple armed gang members, a Special Weapons and Tactics SWAT team was used to secure the residence and grounds before the search. At 7 a.m. on February 3, 1998, petitioners, along with the SWAT team and other officers, executed the warrant. Mena was asleep in her bed when the SWAT team, clad in helmets and black vests adorned with badges and the word police, entered her bedroom and placed her in handcuffs at gunpoint. The SWAT team also handcuffed 3 other individuals found on the property. The SWAT team then took those individuals and Mena into a converted garage which contained several beds and some other bedroom furniture. While the search proceeded, 1 or 2 officers guarded the 4 detainees, who were allowed to move around the garage but remained in handcuffs. Aware that the West Side Locos gang was composed primarily of illegal immigrants, the officers had notified the Immigration and Naturalization Service, INS, that they would be conducting the search, and an INS officer accompanied the officers executing the warrant. During their detention in the garage, an officer asked for each detainee's name, date of birth, place of birth, and immigration status. The INS officer later asked the detainees their immigration documentation. Mena's status as a permanent resident was confirmed by her papers. The search of the premises yielded a .22 caliber handgun with a .22 caliber ammunition box, a box of .25 caliber ammunition, several baseball bats with gang writing, various additional gang paraphernalia, and a bag of marijuana. Before the officers left the area, Mena was released. In her Section 1983 suit against the officers, she alleged that she was detained for an unreasonable time and in an unreasonable manner in violation of the Fourth Amendment. In addition, she claimed that the warrant and its execution were overbroad, that the officers failed to comply with the knock and announce rule, and that officers had needlessly destroyed property during the search. After a trial, a jury, pursuant to a special verdict form, found that officers Mueller and Brill violated Mena's Fourth Amendment rights to be free from unreasonable seizure by detaining her both with force greater than which was reasonable and for a longer period than which was reasonable. The jury awarded Mena $10,000 in actual damages and $20,000 in punitive damages against each petitioner for a total of $60,000. The Court of Appeals affirmed the judgment on 2 grounds. It first held that the officers' detention of Mena violated the Fourth Amendment because it was objectively unreasonable to confine her to the converted garage and keep her in handcuffs during the search. In the Court of Appeals' view, the officers should have released Mena as soon as it became clear that she posed no immediate threat. The court additionally held that the questioning of Mena about her immigration status constituted an independent Fourth Amendment violation. In Michigan v. Summers, we held that officers executing a search warrant for contraband have the authority to detain the occupants of the premises while a proper search is conducted. Such detentions are appropriate, we explained, because the character of the additional intrusion caused by detention is slight and because the justifications for detention are substantial. We made it clear that the detention of an occupant is surely less intrusive than the search itself, and the presence of a warrant assures that a neutral magistrate has determined that probable cause exists to search the home. Against this incremental intrusion, we posited 3 legitimate law enforcement interests that provide a substantial justification for detaining an occupant: preventing flight in the event that incriminating evidence is found, minimizing the risk of harm to the officers, and facilitating the orderly completion of the search, as detainees' self-interest may induce them to open locked doors or locked containers to avoid the use of force. Mena's detention was, under Summers, plainly permissible. An officer's authority to detain incident to a search is categorical. It does not depend on the quantum of proof justifying the detention or the extent of the intrusion to be imposed by the seizure. Thus, Mena's detention for the duration of the search was reasonable under Summers because a warrant existed to search 1363 Patricia Avenue, and she was an occupant of that address at the time of the search. Inherent in Summers' authorization to detain an occupant of the place to be searched is the authority to use reasonable force to effectuate the detention. Indeed, Summers itself stressed that the risk of harm to officers and occupants is minimized if the officers routinely exercise unquestioned command of the situation. The officer's use of force in the form of handcuffs to effectuate Mena's detention in the garage, as well as the detention of the 3 other occupants, was reasonable because the governmental interests outweigh the marginal intrusion. The imposition of correctly applied handcuffs on Mena, who was already being lawfully detained during a search of the house, was undoubtedly a separate intrusion in addition to detention in the converted garage. The detention was thus more intrusive than that which we upheld in Summers. But this was no ordinary search. The governmental interests in not detaining but using handcuffs are at their maximum when, as here, a warrant authorizes for a search of weapons and a wanted gang member resides on the premises. In such inherently dangerous situations, the use of handcuffs minimizes the risk of harm to both officers and occupants. Though this safety risk is inherent in executing a search warrant for weapons was sufficient to justify the use of handcuffs, the need to detain multiple occupants made the use of handcuffs all the more reasonable. Mena argues that, even if the use of handcuffs to detain her in the garage was reasonable as an initial matter, the duration of the use of the handcuffs made the detention unreasonable. The duration of a detention can, of course, affect the balance of interests. However, the 2 to 3 hour detention in handcuffs in this case does not outweigh the government's continuing safety interests. As we have noted, this case involves the detention of 4 detainees by 2 officers during a search of a gang house for dangerous weapons. We conclude that the detention of Mena in handcuffs during the search was reasonable. The Court of Appeals also determined that the officers violated Mena's Fourth Amendment rights by questioning her about her immigration status during the detention. This holding, it appears, was premised on the assumption that the officers were required to have independent, reasonable suspicion in order to question Mena concerning her immigration status because the questioning constituted a discrete Fourth Amendment event. The premise is faulty. We have held repeatedly that mere police questioning does not constitute a seizure. Even when officers have no basis for suspecting a particular individual, they may generally ask questions of that individual, ask to examine the individual's identification, and request consent to search his or her luggage. As the Court of Appeals did not hold that the detention was prolonged by the questioning, there was no additional seizure within the meaning of the Fourth Amendment. Hence, the officers did not need reasonable suspicion to ask Mena for her name, date, and place of birth, or immigration status. In summary, the officers' detention of Mena in handcuffs during the execution of the search warrant was reasonable and did not violate the Fourth Amendment. Additionally, the officers' questioning of Mena did not constitute an independent Fourth Amendment violation. Mena has advanced in this court, as she did before the Court of Appeals, an alternative argument for affirming the judgment below. She asserts that her detention extended beyond the time the police completed the tasks incident to the search. Because the Court of Appeals did not address this contention, we too decline to address it. In Michigan v. Summers and Muehler v. Mena, the Supreme Court held that the police may detain an individual while a search is being conducted of the person's home. What, though, is the... That's the end of the opinion. The textbook just doesn't say it's the end of the opinion. So the end of the opinion was, because the Court of Appeals did not address this contention, we too decline to address it. Oh, there's sort of a little bit more. The court distinguished Summers and explained, in some of the 3 law enforcement interests identified to justify the detention in Summers, none applies with the same similar force to the detention of recent occupants beyond the immediate vicinity of the premises to be searched. Any of the individual interests is also insufficient on its own to justify an expansion of the rule in Summers to permit the detention of a former occupant wherever he may be found away from the scene of the search. This would give officers too much discretion. The categorical authority to detain incident to the execution of a search warrant must be limited to the immediate vicinity of the premises to be searched. The court concludes, a spatial constraint defined by the immediate vicinity of the premises to be searched is therefore required for detentions incident to the execution of a search warrant. The police action permitted here, the search of a residence, has a spatial dimension, and so a spatial or geographical boundary can be used to determine the area within which both the search and detention incident to the search may occur. Limiting the rule in Summers to the area in which an occupant poses a real threat to the safe and efficient execution of the search warrant ensures that the scope of the detention incident to a search is confined to its underlying justification. Once an occupant is beyond the immediate vicinity of the premises to be searched, the search-related law enforcement interests are diminished and the intrusiveness of the detention is more severe. Confining an officer's authority to detain under Summers to the immediate vicinity of the premises to be searched is a proper limit because it accords with the rationale of the rule. Detentions incident to the execution of a search warrant are reasonable under the Fourth Amendment because the limited intrusion on personal liberty is outweighed by the special law enforcement interests at stake. Once an individual has left the immediate vicinity of a premise to be searched, however, detentions must be justified by some other rationale. In this respect, it must be noted that the district court, as an alternative ruling, held that stopping petitioner was lawful under Terry. This opinion expresses no view on that issue. It will be open on remand for the Court of Appeals to address the matter and to determine whether, assuming the Terry stop was valid, it yielded information that justified the detention the officers imposed.